Good afternoon, ladies and gentlemen. Welcome back from lunch. My name is Desmond Ogba. I'm a partner at Templars.
I'm Michael Otu. I work with Zenith Bank.
We are your coordinators for this afternoon's session. This session is titled Creating an Efficient System for Justice Delivery. On this panel, we have 7-man experts, and I would like to invite all 7 up to the stage. The chairman of this session is Dr. Babatunde Ajibade, Senior Advocate of Nigeria, Managing Partner, SP Ajibade & Co. And we have Mr. Fola Atowore, who was former DPP and Solicitor General, Lagos State. We have my Lord Justice Nnamdi Dumba of the Federal High Court. Mr. Olusegun Abimbola, Attorney General, Oyo State. Mr. Segun Oshitokun, Partner, Berin, Layton and Pesner. Another Leonard Silk, Otto Obiokafo, Principal Partner, Otto Obiokafo Associates. And the only lady on the panel, Igoniko White, Partner Templars. As you can see, your panel promises to be an interesting one. It is drawn from all sections, all parts of the profession, the bench, the inner and the outer bar, and of course, a foreign practitioner present with us here today. We will now hand you over to the chairman of the session. Let me see you, sir.
Thank you, Desmond and Mike. Good afternoon, distinguished ladies and gentlemen. Welcome to this after-lunch session. As in, what should I say about Chiedu's "Let us have light" intervention? This session is a session that's particularly dear to my heart, and I think it should be dear to the hearts of all of us as lawyers, because I think it affects everything we've been talking about before now, at least in the 2 sessions that preceded it today. I think the desire for an efficient system of justice delivery affects us as business lawyers, perhaps more than it affects those engaged in other aspects of legal practice. There was talk earlier about how we protect our turf, but we're not going to protect our turf if we spend 8 years, 9 years litigating about where to litigate. And those are some of the things that you see happening in our judicial system. So this session, we're going to try to unpack this. And there was so much that was said during the earlier sessions that I thought I give kudos to the SBL, because the way these sessions have been arranged, it's almost like they're connecting the dots. There was a young lady who spoke up during the second session who said, well, you know, when are we going to stop talking and actually doing something? And I think as SBL, as the NBA, as a section of the NBA, we have to make sure that we leave this particular conference with concrete takeaways and concrete decisions as to things we need to do to change the way we operate. We couldn't have chosen a better speaker for this session. Yes, Mr. Atoware's profile is in the program, so I won't bother reading it out. Please read it. But I'd like to, there's a portion of it that I would just like to emphasize, which establishes why he's the perfect man for the job. And this is the paragraph that says that he was deeply involved in developing and implementing the judicial reform processes under the direction of the current, acting president, Professor Yemi Osinbajo, who was the then Attorney General of Lagos State. And then in 2008 and 2017, he chaired the Lagos State First Level Justice and Magistracy Reform Committee and the Lagos State Blueprint Committee on Justice Reform, respectively. So when you listen to Mr. Atawari, you can rest assured that he's not just talking theory. He has been there, he has seen it, and he has done it. The way this session is going to run, we've got an hour and a half. Mr. Atawari, I'm going to kick in and screaming, limit him to 25 minutes. And then I'm going to give each of our discussants 6 minutes to address a specific aspect of what Mr. Atawari has said. Because I want to make sure that just like the other two sessions, this session is interactive and that we have an opportunity to exchange ideas. So without further ado, Mr. Atawari, please.
Sorry, the stick thing. I thought I was informed that I'd be given the thing. All right. Aha, there we go. Perhaps, right. Thank you, distinguished chair, my distinguished co-panelists, and distinguished ladies and gentlemen, my dear colleagues. This is an intimidating audience, I must say. Let me first of all thank the organizers for putting this together. We keep on addressing these issues, and there's still a lot to be spoken about, and this is just another step forward in the process. So I'm told I have 25 minutes, which for me is very difficult. So there'll be no asides, no jokes, no extrapolations, just straight talk. So the topic, as you've been told, is creating an efficient system of justice delivery. So I put together a paper, I think next page, good, it works, I'm surprised. I put together a paper that sought to address some of the issues of efficient court systems from the perspective that I see it, both as someone who was involved in the process, someone as an observer and a listener, and someone who has tried to sort of develop some reverse engineering approaches to the problem. So I've looked at it not from a lawyer's perspective, but from a manager's perspective. So the issues that I was given to address are: what would the cost be? What would the benefits of having an efficient system be? Do these benefits justify the investment? And what are the critical reform measures and attitudinal changes required? And what is required from the three arms of government? And then a comparative analysis of what obtains in other jurisdictions. So I developed a scheme, so to speak. I said, and critical and central to my paper is this first issue: the need to recognize the important distinction between the administration of justice generally and the administration of the courts. Two elements of management that are often conflated. For me, this is at the heart of the problem of efficiency. Then how to develop an outcome-based governance philosophy, etc. The importance of written policy. Why intent without will is ineffective. I intend, we intend. We've been intending in Nigeria since 1960. We intend. When are we going to deliver? And then the establishment of a duty mindset and the importance of an organizing principle, which I think is one of the key things we lack. Even if we adopted the organizing principle of punctuality, if we just said that is the organizing principle of all our business, then all other elements would have to collapse around that principle. But it doesn't appear we've done so. And then the importance of first principles. So I then said, preliminary issues. What would constitute an efficient justice delivery system? How can we attain this in our extremely adversarial environment? And we are operating in an adversarial environment. So you can't make any presumptions. There's no power, which is key. There are no systems as such, etc. Then should we not be realistically seeking an improved rather than efficient justice delivery system? So we take it step by step. And then examples in other countries. What can we do differently? And I've made some proposals about that. And what would it cost? Impossible to say. That's what I say. Impossible to say, but whatever it will cost will be worth it, in my view. It would be impossible to say until we have constituted the new system. So I'll jump this and go to, okay, what would constitute efficient justice delivery? Quickly, I said there should be overall clarity of process and operation. You ought to know what to expect when you approach the courts. Many times, for instance, you can be hit with extra costs that you didn't anticipate. And when you say, when were these introduced? They say, well, that's how we do it now. Where's my receipt? Come back tomorrow. So there's something inherently corrupt about that kind of system. Then it should be well organized, which is always a challenge. Organization is a challenge to us, except in short bursts, such as, for instance, the management of this conference, or like I recently organized my mother's 90th birthday party. We're good at that. Canopy, this, color, blah, 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 food. And then it's over, and we go back to our way. Then predictability, I said orderliness. Should not saddle the customer with additional costs or delays due to unpredictability or uncertainty or incompetence or inefficiency. So when judges or officials of the court suddenly up and leave to some unplanned conference or retreat, etc., then that's the unpredictability. And of course, it leads to delays and costs, etc. Then forward planning. So because there are always contingencies. Then effectively and constantly communicate every process. We're all good with our WhatsApp and Instagram and so on, and yet the court will not inform you that it's not going to sit. I don't get that. It's strange. That's a strange approach. With all the things that we do, everybody here has a phone, etc. So, and that's because there's no operating manual that says this is what should be done. Then I said adequate funding, whose expenditure is rational, prioritized towards efficient service delivery, and properly accounted for. So adequate funding, of course, is debatable, but if courtrooms in a system are leaking and the generator is not working and the toilets are broken and the IT system is down and the court owes service providers, because we're always talking about outsourcing, but you have to pay your bills. Otherwise, the outsourcer will withhold service. So if you are faced with that, and then suddenly 30 judges go to Dubai for a retreat and spend 3 times the amount required to address some of these problems, then that is not rational spending. So those are the kind of things we have to confront. You know, what we do must make sense. And then it must have effective court building and equipment maintenance systems that will enable staff to optimize output and guarantee clean, orderly premises and facilities, adequate sitting areas, public conveniences, and address the fundamental issue of power supply. Fine. So we'll jump. This is a continuation, I think, and move on. Right. Why have we not attained the levels of efficiency required to establish a fairly functional, if not perfect, justice system? There are no perfect systems, but, you know. So we say there's a lack of clear and coherent judicial and administrative policy by the NJC. Asking judges to make returns is not policy. That's just process. And it goes to know you can't enter any database now and see an analysis of those returns and how they impact on the administration of justice. And people work their returns the way they deem fit. So if you say a case is completed, what exactly does that mean? It may mean that you've done the ruling for the first motion, etc. So there's no clarity in that. Then weak institutional governance, I've said, lack of decisiveness and willingness to improve current conditions, pushback by the judiciary itself when confronted with the prospects of change. And we've seen that a lot. People have proposed that there should be a court administrator who manages the physical and system elements of the court, but they want complete control. CJs and CRs want control. Then an over-focus of attention on the activities of individual judges. Critical administrative management duties being deferred with no accountability. Indeed, most of Nigeria's public space is the impact of deferred decision making. That's what it is. So you listen to the power presentation. It's all about deferred. What should have been done before? We're still waiting for it to be done. You collapse that with things deferred today, deferred tomorrow, etc. That's the space that we are in. And that's why most public infrastructure is in such poor state. Because things that should have been done years ago were not done. Now, then weak disciplinary action, I've said very little consequence management, especially for administrative staff. Weak judgment enforcement mechanisms. Sometimes unruly, I say sometimes, underline sometimes, unruly and unscrupulous bar who are overly indulged by the system. Ideally, the individual should adjust to the system, but here the system often adjusts to the individual. And of course, with that, we have very large egos in Nigeria, so that contributes to the problem. A lack of clarity as regards funding sources, and I think that's important. Too much significance given to outdated traditions. For instance, why do we still have the yearly vacation period? Well, I don't get that. Summer. It's colonial. No other system that's in such arrears takes 3 months off in a year and goes to sleep. It's just not done. I mean, and if the judges, as they will, and certain senior lawyers who will say to the court, my lord, this is the time I usually proceed to London and all of that thing we do. It's just, if we're not going to be able to stop the vacation, then let them go. At that point, those in charge of the administration of the physical court will move in. They'll have a 3-month period of complete maintenance and repair work. So when the judges return, everything will be working. You can't just throw away 3 months of a year as a system. So, all right, so I know that I'm running out of time now, so I better, before somebody comes and shows me. So we know what the benefits of an efficient system. Sorry, where did I? Okay. All right. Need for clear policy. I said that there needs to be clear policy, particularly with regard to costs and when to strike out a case, etc. Matters that judges are often afraid to do because there is no guidance. I know that judges of the High Court often say they won't strike out a criminal case because they are afraid of public opinion. Then who is going to end the process? Example, we talk about fast track. How many minutes do I have left, sir? 7 minutes. 17. Oh, sorry. Sorry. And I'm not, because we're talking about efficiency, I won't be able to ask for extension of time. But anyway, let me give you a quick example. We talk about fast track system. So you pay a little extra, it falls within the category, you fast track it, so to speak, and then it comes before the judge for hearing. But because a NEPA bill of 5,100 naira was not paid, again a deferred action, was not paid when it should have been paid, 5,000, and I'm talking from experience, 5,100 naira, a ridiculous amount, an amount that you could pay from your pocket and collect later. But because it wasn't paid, NEPA took off power. And because you didn't pay the person who supplies your diesel, there's no diesel in the generator. So your fast track is aborted by a system failure. So if we don't connect those dots, we're just wasting our time. And it is not the CR that should be worrying about the payment of that bill. His worry should be to get the case on the fast track, while the other system deals with these others. That's how rational systems work. But lawyers, sometimes, I wonder. Anyway, so, is this deliberate to keep me? Oh, finally. All right. So I think I have 7 minutes left now also. Okay, so I said, recommendations for improved governance. Legislation, judicial policy, etc., organizational audit, detailed operational manuals. You cannot run a public court system without manuals, operation manuals, so people know what their functions are and the public knows how the system will operate. Because we have no operational manuals, staff impose whatever conditions they like, and we accept it. So it is key that to run the court system, we need clarity by virtue of the development and publication of operational manuals. Then this will cover maintenance, etc. But let me move to finally, because I know I don't have time, and I think it's key that we should look at funding. Right. Now, but before I go to funding, I looked at 4 examples of the court administration system that distinguish between administration of justice and administration of the courts. I looked at South Africa, Kenya, the US, and the UK. In the US, the UK, and South Africa, they have dedicated court administration structures that deal with the facilities for the support of judicial staff. They are clearly distinct. They are run by the executive, and their role is not the administration of justice, but the administration of the courts to facilitate efficient administration of justice. In Kenya, however, they have adopted the Nigerian model, or should I say they have a similar model, where the CJ and the CR run both elements. And of these 4 examples, the Kenyan example, the courts are in the worst condition, and their system is the least efficient. So we recommend that the judiciary should let go of the management elements, because it doesn't have the capacity to deal with IT systems, maintenance, power, etc. Let a specialized body do that. Now, funding. We've all heard about the independence of the judiciary and financial independence. This is my final point, sir. I've not been able to do justice because of this time limit, but then sometimes efficiency gives you less substance. So, there's always a trade-off, I assure you. I could have just gone on and on, but that would be inefficient. So, let's look at the thing that there was a lot of, let me use the Nigerian expression, hue and cry over. Financial independence of the judiciary, purportedly conferred by the Constitution. And there were all manner of strikes, JUSON, which some people allege, because I wonder what the junior staff of the courts were doing on strike, but some people said they were being, let's not get into conspiracy theories. All right. So, on what premise is the argument for financial independence for the judiciary based? It is based on the Constitution, Section 162, Section 162(9), right, of the Constitution. And 162 is about public accounts, essentially about distribution from the Federation account. It says, any amount standing to the credit of the judiciary, underline, standing to the credit of the judiciary in the Federation account, shall be paid directly to the NJC for disbursement. Money that comes into the Federation account goes out according to these. There is no reference whatsoever to any percentage due to the judiciary. So where is this financial independence we talk about? So sometimes we don't we're not thorough enough when we. So we need, as I say, to make up our minds. One, to amend the Revenue Allocation Act, and the MBA should push that. But two, whether we should amend it so that the funds actually go to the judiciary, or whether it should be to the management arm that we speak about. So I think that's a critical issue. That, and then, as I said, the question then will be, under current conditions, even if we gave the judiciary full independence and it had all the money it asked for, under current conditions of management, would it be able to deliver an efficient court system? I say no. I say the system as currently is extremely flawed. So finally, I think there are a number of issues we need to look at. The costs or fees for entering the court system are too low. Access to justice is a wonderful thing, but more so is exit. Cheap entry, no exit is not a system. If there is a category of citizens that cannot afford the regular fees, then the executive or pro bono or NGOs should cover that. We shouldn't impose cheap fees across the board that do not reflect in reality the cost of the service. I know the activist judges will say no, but the activist lawyers, but that's the reality. Finally, who should be involved in the process? In my view, the court should be ready to concede management power to bodies that are efficient enough to do it. The legislature needs to make clear legislation in terms of the role as between the executive and the judiciary. We need to clarify this issue of judicial independence in terms of finances and how to effectively implement that constitutional provision, which, as things stand now, is not implementable. And finally, as for the lawyers, I think that if the system is improved, lawyers will have no choice but to amend their ways to suit the system. And those found wanting should be quickly dealt with by the professional and disciplinary bodies within the MBA. Thank you very much.
Ladies and gentlemen, I'd ask you to please give Mr. Athawari one more round of applause. When I had the privilege of reading his paper ahead of time, and I spoke with him last week, and I was trying to pigeonhole him into 25 minutes. I wish you could have listened in on the conversation. He made clear to me that he thought that it was ridiculous asking him to deal with this issue in 25 minutes. What we will do is to ensure that his paper is circulated to all attendees, because it's very rich. It's a very rich paper. This is really something that requires a whole day seminar to unpack all the problems we have with our administration of justice system. But at least for those who are foreigners, at least the few foreigners we have amongst us, who instruct Nigerian lawyers and who are mystified when they are told that, the matter didn't go on because there was no light. At least now they understand the reasons why we end up in these embarrassing situations. What I've asked, or what we intend to do, the distinguished panel you have here, they have different areas of strength. And the next speaker, who used to be one of us, who perhaps like Mr. Ugbo will claim that he's still one of us, but has crossed the divide, I think Mr. Athawari's paper challenges him. Because one of the things I think most of us as practitioners have always puzzled about is why our colleagues who were with us at the bar, when they cross over to the bench, the things we all used to complain about together when we were at the bar, they find it a bit difficult to maintain that position. So the next speaker is Honorable Justice Dingba, and the specific question that I want him to address is, having read Mr. Arthur Warry's paper, to comment on whether he thinks that indeed the administration of justice and the administration of the courts should be separated, and if so, what is the best way to go about it? Justice Dingba.
I think the thing to do is to recognize that the justice sector is not quite where it ought to be. Whether one is speaking aspirationally or you're speaking factually, is not quite as where it ought to be. But, having said that and having recognized that, sunlight is the best form of disinfectant, which is why we're having this discussion, I think it is also important for us to call an elephant and not call a horse a horse. That is to say, I think for me, the best way to proceed is for me to sort of slightly reset the theme of this discussion to a slightly more favorable note, and to say that if you look at things very critically, I do think that the justice sector is in a much more improved state now than it used to be before. And I say that because I remember, for example, when I was in the law school in 1999, and I was doing chambers attachment, and I used to follow some of the lawyers to the courts, and I could see, how difficult it was to get anything out of the courts. Simple motions. When we were going to the courts, we used to pack a lot of books into the cars just to argue a motion, and it takes you ages and nothing happens. But I think things have improved now, and a number of things made that possible. I can look at the reforms that we saw through the the new rules of court, this issue of front loading, this issue of written addresses. All of them have made the justice sector, delivery sector, in a much better shape than it is, at the moment, particularly in the civil procedure aspect. But criminally, there are still problems of delays and all of that. And I had thought maybe I should just throw this, forward for us. If you look at the Federal High Court, for example, we have this practice directions for criminal trials that requires front loading, the way you have it in civil procedures. But you don't have issue of sworn witness statements. And I was just wondering, wouldn't that also contribute to greater efficiency if we also had sworn witness statements for criminal proceedings? But the point I make is that with the case management powers which the rules of court have given to the judges, I think the justice sector is in a much more improved state now than it was before. So for me, it is not a case of a rescue mission. For me, it is a case of making what is good better than it is, given that there's room for improvement. That's it. And I think it's because of the recognition of the inadequacies that are present, notwithstanding the progress which has been made, that one finds in the point which Mr. Atowari made about this issue of confusion of the administration of justice and administration of the courts. Yes, I believe they're different, both in terms of concept and in terms of functionality. They're different things, okay? Because for administration of justice, that deals with intangibles. But when you're talking of the courts, you're dealing with tangibles. So therefore, I think some sort of efficiency is lost by the fusion of these two. The suggestion which Mr. Atowari made about the whether wouldn't it be nice for you to separate two of them and to give the administration of the courts to an executive agency or some other body. I want to say that, perhaps as a question of accountability, that's a good idea, so that you can have somebody you will say that this person is going to be accountable for the state of the courts. So that's something to welcome. But I have to say that in terms of producing results, I think that's a suggestion that we have to take with some qualification. Why? Because I believe somehow it is built on a sort of a false premise. And that premise is that if it is in the hands of the executive, they're going to manage it better. I say no, because why do I say that? Some of the facilities which are run by executive agencies, in what state are they at the moment? One goes to hospitals, you go to airports, you go to a number of facilities which are run by the executives. They're not in a better shape than the courts. One can even argue that the courts are in a better shape than some of these facilities. I think the key challenge for us is, how are we going to import into the public sector the efficiencies of the private sector in Nigeria? Some of those efficiencies, how do we import it into the public sector? And that is a question, both for the judiciary and for the executive. But here we're focusing on the judiciary. And I tell myself that, whether the administration of the courts is with the judiciary or is with the executive, what is important, what matters for us to have real results is for us to have an importation of some of the efficiencies in the private sector, the good private sector anyway. Not every private sector is efficient to the public sector. And I've thought of a number of things that can be done. One is that you have to devise a means of recruiting smart people into the judiciary, into the justice sector. But how possible is it? You look at the issue of remuneration. What do they earn, for example? I ask this question: why would a judicial aide and a legislative aide earn more than a judicial aide? Some of the guys who work for me, who work in the courts, some earn 30,000 naira a month. How do you expect them to give their best in terms of managing facilities? I think we have to do a number of things. Bring in mechanisms to attract very good people, proper budgeting and funding. Once all of these things are there, I believe we can have good results. But to the question, in terms of accountability, that's something to consider. But in terms of having real results, as long as some of the factors, elements which exist in Nigeria's public sector today still exist, even if you make that transfer of control from the executive, from a judicial body as exists at the moment to an executive agency, you're not going to have much. And I can tell you this, and quickly again, the examples which Mr. Atowore gave about 4 jurisdictions, Kenya, South Africa, the US, and the UK, it is not necessarily because the courts are being managed by executive agencies, simply because the public sector there is very efficient. That is the fact of the matter. Even if you were to give the courts to the judiciary in England or the US or South Africa to manage, it's going to be in a much better shape than Kenya anyway. You understand? Even if Kenya has been managed by an executive body in Kenya. So that's just the fact of the matter. So very brilliant paper. I do agree with the conclusions. But for me, I think there are a number of things we need to do. Once all of those things are done, even within the existing framework, you're going to have good results. Thank you very much.
Thank you, my Lord Dingba. I omitted to introduce Justice Dingba in any detail because I know we all know him. But for the avoidance of doubt, for those who might have forgotten him since he crossed over, his profile is at page 39. He's a competition law expert and was a partner at Olaniwa Jaya & Co. before he went to the bench. Now, the next speaker, and again chosen carefully because we put the one arm of government on the spot. We think that one of the points Mr. Atowore has made is that perhaps the administration of the court will be better handled if it were to rest with the executive. And I think a lot of these things require a champion. And within the executive, there's no better champion than the office of the Attorney General. So our next speaker, who is also a member of the family, is a consummate barman, or was a consummate barman before he was dragged into government, Mr. Olusegun Abimbola, the Honorable Attorney General of Oyo State. He's going to address us on Mr. Atowore's paper generally, and he's going to address specifically whether he thinks that the recommendation that the administration of justice of the courts should be handled exclusively by the executive is workable within our current constitutional makeup. Mr. Bimbola.
Thank you, Chairman, distinguished panelists, distinguished colleagues. I must say that when I got the lead paper a few days ago, I was quite excited with some of the contents, particularly the points just made with respect to the recommendation of taking out the management of the court facilities from being under the purview of a chief registrar or a chief judge. And the reason why I say this is because I'm actually in the middle of a discussion along those lines, and those conversations are still ongoing, particularly with respect to drafting operational protocols, and that I'm trying to do by virtue of being a member of the Judicial Service Commission. Now, the Judicial Service Commission most times is relegated to merely deal with appointments and discipline of judicial officers. But I think that structure actually, if expanded, empowered, can actually serve the purpose of management of the facilities. And it's going to take a little bit of tinkling with, a little bit of savvy to snatch away power from those who have previously enjoyed it. But that conversation is ongoing. And I think that the recommendation made by Mr. Othawori is commendable. It's something that I'm sure some of my colleagues in other states are probably having this sort of conversations already. And so I'm sure that in time to come, we will be able to put together a structure that works. More importantly, with our current experiences, I think it's even in the best interest of the judiciary, because it also helps to insulate our judges from some of the issues and procurement scrutiny that comes with the administration of the court facilities. And I think we need to try and insulate our judges from those kind of developments that we begin to see. I took time to do a quick survey, particularly referring to the World Justice Project that came out with a release of its annual Rule of Law Index of various countries. They actually surveyed 99 countries, and they did a survey using about 1,000 people in each country in 3 major cities to be able to identify the limits of government powers, issues of corruption, civil liberties, and crime, for them to be able to identify 10 countries where they said justice prevails. And I think when we talk of creating an efficient system of justice delivery, it is because the discussion starts with what justice is. And I like the way Mr. Othawori puts it, stating the fact that justice is deemed delivered, whether by virtue of the system being able to either declare what is right, enforcing a right, preventing a wrong, or punishing a wrong. When you have these indices present in the outcomes, then you can say justice has been served. And so this institution, the World Justice Project, tried to address that. And these were their findings. I will give their list in an ascending order. Country number 10, I'm just talking about the first 10, is Singapore. And they scored Singapore number 10 based on the fact that they consider the country best on matter of order, security, criminal justice, and anti-corruption. They scored Germany number 9, identified the country for their gains in matters of civil justice and the ability to constrain their government from interference in the due process. And so you can see the various indices that they use to mark countries. Number 8 is Australia. Number 7 is Austria, equally noted for its fundamental rights delivery and criminal justice performance. Number 6 is New Zealand. Number 5 is the Netherlands. Number 4 is Finland. And Finland is actually reported to have the best criminal justice system in the world. Number 3 is Sweden. Number 2 is Norway. And of course, number 1 is Denmark. I don't know why they all look Scandinavian, but it seems that's where justice is. You might think of relocating. Now, clearly, it is not just the structure, it is a lot of it will turn on the operators of the structure. And that is yourselves, ourselves, the bench, individuals, lawyers, and all of us. I know I've had a discussion with the chairman on one of the critical issues which he mentioned this afternoon, and that's the issue of litigating about where to litigate. I was talking to one of our judges, and they did tell me that 50% of preliminary objections, either in the High Court or even interlocutory appeals, are based on jurisdiction. And so you know that if we're able to deal with that foundational issue of jurisdiction, then half of the litigation that goes on appeal will be gone. And the simplest way to deal with it is to just put a little clause in the Constitution, just like you have it in the Federal High Court Act, that they can transfer if they don't have the jurisdiction. They can just transfer to the state, but the state cannot transfer. There's no reciprocal powers, except you amend the individual high court laws of 36 states. We're in the middle of that right now in Oyo State to amend our own high court law to allow the state to transfer, not just to the Federal High Court, but also to the NIC. I know the NIC has in its own acts the power of transfer, but that is still arguable whether the NIC acts can legislate that the state can transfer to it, but they can transfer. But if it were to be in the Constitution, just like the NIC had its third alteration inserted in the Constitution, that this court has this jurisdiction under Section 251 Federal High Court, Section 272 High Court, 254 NIC, and then you have a clause that says that wherever any of the courts find that they don't have jurisdiction in the matter before them, let them transfer to the place where jurisdiction lies. And that will simply take away these consistent issues. Of course, it will take away some of our litigation matters as well. Finally, I'd just like to make a call to all our colleagues. You know, even at the official bar, I talked to my colleagues in the Ministry of Justice that a time is coming when we will no longer be able to hide behind the facts or the statement we normally make that the state does not pay cost. A time is coming that the state will be required to pay cost. And so, before that time comes, we need to build efficiency, not just in private practitioners, but also in our various ministries of justice all over the country, so that even though I talked to a friend of mine who sits now as a judge, and he was lamenting that you guys come to court, you adopt written address and go to sleep. You forget that we cannot adopt our judgments. We will have to dig in, read over your address. If there are 4 or 5 lawyers in the case, then you have 5 addresses to read, plus replies as well. And I told him that, well, we have 5 days. And if we don't file within 5 days, we get some penalties payable, 200 naira per day in some cases. If you're lucky, it's a federal high court, it's 1,000 naira per day. But in your own case, if you don't deliver judgment, even after 3 months, nobody asks you to pay anything. So in that wise, we also need to look at that. Thankfully, the NJC is already doing that with respect to putting some motivational compliance. Thank you very much.
Yes, Honorable Attorney General, thank you very much. And I think you've taken us very neatly into our next set of discussants, because we've heard from the expert, we've heard from the 2 arms of government. We now need to hear from those that actually operate the system, and those who some say are actually the cause of the problem. Because as has been said, no matter how good the rules are, somebody has to operate those rules. we have three distinguished legal practitioners who are going to address us. But I'll start from Mr. Arthur Obiokafo, SAN. In one of the earlier sessions, there was an accusation made that the senior advocates are the crux of the problem. They're the ones that get into court first. They jump the queue, they hog the time, and leave very little time for the administration of justice to go around. So I'll ask Mr. Obiokafo to address this accusation that has been made, and basically tell us what he thinks the role is that lawyers are playing in the efficiency or inefficiency of the administration of justice, as the case may be.
Good afternoon, colleagues. Mr. Chairman, you know I have only 6 minutes, and you're creating much more work for me without adding any more minutes to me. On the issue of senior advocates coming in anytime into the court and taking up his matter first, leaving other lawyers who may have been waiting there for quite a long time, that system cannot be encouraged. And we believe that if there is proper scheduling, we see that in the election matters, there could be about 4 or 5 petitions pending in the court. The tribunal will now say, look, come in by 9 o'clock, you take 2 hours. You come in by 11, the other side will come in by 11, take another 2 hours. The other will come at the evening session. But so we are saying that there could be scheduling of these matters so that even junior lawyers will know when they will come into court and have the matters done, instead of the senior advocate taking the whole day doing his case. But that depends also on the system, because it's not something that a judge sitting in a court will be able to do alone. It's something that the entire system, the registry and very capable staff will assist the judge to be able to administer the court properly. Let me go to what I ought to talk about the delay occasioned by counsel who appear in the matter. I just need to give you 2 examples. The case of Obuyin and Okudo was filed in 1958 or thereabout, either 1957 or 1958, and there was an objection on the validity of the writ. The matter traveled up to the Supreme Court and came back. After that objection, Nemkago gave a judgment in that matter. When the matter came back to the High Court, he gave a judgment, but that judgment was challenged on the ground that at the time he gave the judgment, it had been elevated to the Court of Appeal. There was a gazette published. So when the matter got back to the Supreme Court on the second missionary journey, the Supreme Court agreed that at the time he gave the judgment, he had no reason to do so, and the matter was sent back again. So now the substantive matter had been tried, and judgment had been given in the High Court. The matter went to the Court of Appeal, and finally the matter is now resting in the Supreme Court. So the matter that was filed in 1958 is still pending. That is one example. Your guess is as good as mine. Why it is still there? I won't say more. Then there's another one that was filed in 2015. This is just a matter involving cooperative trustees. And the defendant raised an objection that the court has no locus, that the plaintiff had no locus standi, and that the matter ought not to come by word of originating summons. The ruling was delivered. The court held that the matter ought not to have come by word of originating summons, but that the plaintiffs, that they had reason to file the matter. So the appeal was now filed by the defendants who now went to Court of Appeal, Enugu Division. There, the Court of Appeal now looked at the matter, and based on the new practice direction, which they have, the Court of Appeal has, the Court of Appeal now said, look, what do you have to lose? He was asking the counsel for the defendant, what do you have to lose if you go back to the High Court and have this matter tried, and then you come back to us with all your complaints so that we can take it, one whole hog? The lady said, or the counsel said, we don't have anything to lose. Even though briefs have been filed, the Court of Appeal now said, look, you have to go back. He struck out all the connected matter, and said people should go back and have it tried. We thought that was the end of the matter, but no. Before we knew what was happening, we were served again with notice of appeal from Supreme Court. And then this time, I was wondering, look, you said you had nothing to lose, there was no credit. Why do you have to file an appeal to Supreme Court? He said, my client said I should do so. So these are just two examples, and showing that at most times lawyers are not even in control. They don't show control of their proceedings. They allow their clients to dictate to them how to go in these matters. So I must say with all a sense of responsibility that lawyers most times are also part of this delay in the judicial system, and we must tell ourselves the truth and have a change of heart in the way we conduct our proceedings. Now, cost, they say follow events, and lawyers also argue that cost should not be punitive. But you see, in the situation we have found ourselves, which I think we are in the state of emergency, cost should be punitive, apart from following events, so that people will be discouraged from filing frivolous appeals. Most delays we have today is based on interlocutory appeals. And even when the practice direction are giving the Court of Appeal the powers to manage cases before them, lawyers are still finding a way to circumvent that. So there should be indemnity. If you want to go on appeal on a matter, especially even if it's a final judgment, you have to deposit money, good money that will cover the delay which we witness in the system. So if you know that the matter is frivolous, and you know your client will pay up to 10 million naira if he loses the appeal, you have a rethink whether to go to appeal or not. Because we don't have time, I have to be rushing. And I'm also saying, respectfully, even though this is not part of, but it also dovetails into what we are discussing about, that if you look at the cost we have the, first of all, we had the Federal Revenue Court, and later which metamorphosed into the Federal Court, and subsequently now we also have the National Industrial Court. Attention is not paid in our court system to commercial transactions. They are even treated as if they are treated in the same level with land matters. But I assure you that if we are talking about attracting foreign direct investment, if we want flow of foreign exchange into Nigeria, we must make sure that commercial matters are tried expeditiously. Yesterday, at the opening session of this SBL, we found out that many of the speakers talked about ease to do business in Nigeria. Efforts being made to ensure that there's ease to do business. Yes, that is good. If you have the ease to do business, what about the ease to recover your money if there's problem? If there's problem and you can't recover your money, or if there's this threat that your money will not come back to you and you are a foreigner, I can assure you, you wouldn't like to put your money in Nigeria. So it is important that we will also be talking about how would the interests of these foreigners be protected, even our own people be protected. So we must make sure that these commercial transactions are treated expeditiously. And by so doing, we now attract foreign investment, and then we have more industries, the SMEs will grow, and more businesses will come in, and the people should not see the loans they get from the banks as part of what I call this is the amount that belongs to the government. It doesn't belong to anybody. They take the money, and before you know it, they go to court. So banks are unwilling to even give loans because they know that the person who's collecting from the inception had no intention of paying back the money. And because of delay in the court system, he goes away for years. This matter will be pending in court. So there must be a way to ensure, if it means having a party direction on that, about giving primacy also to commercial transactions, primacy to commercial transactions, so that matters will be expediently done, so that people will now bring in money into the country, knowing that their money will be preserved and safe, and then the economy will grow. And if the economy grows, that will help in sustaining the court system. We are talking about automating the courts. Where will you raise the money to automate the courts? You raise this money if the economy is buoyant. Both our foreign and state and domestic policies are based on strong economy. If our economy is not strong enough, there's no way we can raise good foreign policies and also raise good domestic policies. So I think that we should give more attention to commercial transactions in our courts. For now, there should be reform anyway, but that may take a longer time based on legislation. If we have legislations that would say there should be special courts that deal with commercial matters, or to restructure the ones we have and give jurisdiction to these courts. But then, if time will not, if time will be taken, much more time will be taken to have legislation of that matter, we can have party directions that will deal with commercial transactions, which will make sure that these matters are expeditiously treated and handled so that the economy will grow. I'll leave it at this point. Thank you, gentlemen.
Thank you, Leonard San. We've heard from the inner bar. We'll now go to the outer bar. Ms. Igoniko White is a partner with Templars, and she's going to give us the view from the outer bar. One of the things Mr. Obi Okafor has said is touched on the question of costs. We know that in certain jurisdictions, bringing frivolous litigation can ruin a litigant. Even if you decided to go to court just to buy time, you might find that you end up owing more than the original claim just in cost. And I think that is a very, very powerful deterrent to frivolous litigation and helps assist the efficiency of those judicial systems. So the question for you, Ms. White, is do you think that our system can gain from adopting a similar system where, for example, you have full indemnity costs? So say, for example, Mr. Obi Okafor's client wins the case, having paid him those heavy fees that senior advocates earn, the losing party would have to pay those fees back. Do you see that working? Ms. White, please.
Permit me, Mr. Chairman, to address this question from where I am. Certainly, that's the short answer to it. Like you said, in most other jurisdictions that we know, UK, for instance, even if it's not full indemnity, but at least 70% or substantial, you must bear the cost for wasting the time of the court or wasting everybody's time. So you don't just bring any frivolous application or bring all sorts of delay antics in order to earn fee, in my view. Sometimes I think that's why the reason why some lawyers would want to go through all that long haul, because they want to earn their fee or just to complicate the matter. So if we do adopt this system that we have in the UK, where you would pay for the cost or you pay full indemnity cost to the winning party whenever you lose an application or you lose the case, that would be a good deterrent. And also, there should be some reforms, in my view. Particularly, I find that a lot of times when counsel go to court to seek adjournments, judges, perhaps it is a discretion that they need to exercise, but maybe they have to, take it serious. You don't go to court just because you want to seek an adjournment. A matter is on the list for mention, and that is all you've come to do. I mean, there should be, those sort of mentioned matters perhaps could be taken, if we talk about IT, virtual, for you to go and apply and take all those matters that are non-contentious, so that when you have a date for hearing, in order to decongest the list of the court, you have serious cases that are ongoing, and counsel come and finds all sorts of excuses to have a reason to ask for an adjournment. And a lot of time I've seen, judges are willing. They said, oh, okay, they want to do justice, they'll grant you. I think that is not even doing justice. That is justice delayed. We must have that firmness, in order to say, if you have come for business, this is the business, you should be able to go through. Even if you send a junior associate to hold your brief, that junior should be ready to go on. So another thing I see that I think should be encouraged amongst lawyers is encouraging out-of-court settlements, either by way of arbitration or the other ADR processes. We have arbitration, you have the negotiation. For me, I think lawyers look at it from the angle of either ticking the box, because maybe the rules of court expect that you should try and resolve the dispute. They really don't want to go into it deep with the objective of really getting the matter settled. If we are able to settle a lot of all these cases, especially the conventional cases, by arbitration or other means by which you can settle this dispute, you have decongested again the list, and matters that of course may not be, perhaps you cannot settle by way of arbitration, would be the ones that we can take to court and deal with them. So I'll give examples. For instance, there is this case that I'm personally involved in, and it's a case for, I think, about 700,000 naira. It was filed in the district court. I'm simply telling my clients, seriously, how much can you pay me for me to go and defend this case? Do you think that this is something we can resolve at this stage. Talk to the client to make them understand that it's not every case you take to court. You try to get them to, find ways to resolve the dispute. And the client said, oh, well, yeah, I want to fight it to the end. I said, okay, let me tell you the cost implication of fighting it to the end. You will be paying lawyers' fees. You would also, perhaps at the end, if you lose, also pay that money. So where do we go? Do we not just pay this money, make the case academic at the end of the day by just simply saying there's no more life issue? So perhaps you talk about issues of damages. But curiously, you find the defendant, co-defendant on the other side say, no, why should we? Let's take it up. Let's drag it to the highest point. And that is, amazing for me. I'm curious. And I can only think that it's because he wants to earn enough of his fees. I think sometimes even when you are able to deliver value within the shortest time, you should still be able to earn your fee. And I know that there's a lot of, when you talk about arbitration, for counsel who are involved, there's enough to go around in terms of fees. So for me, these are the things that I think even as counsel, we should encourage settlement out of court, and not to settle by way of arbitration or negotiation and then still come to court to challenge the award. That's another practice we do. We get an award, we never look at that provision of the act that talks about it being final and binding. No. We want to exercise our right. There's always that need to exercise your rights. So where does it stop? There's always, you want to get to the last resort, the Supreme Court, before you know that, okay, well, there's nowhere else for me to go. So that is a mindset which as counsel we should also seek to try to, change and be more efficient in order to have overall an efficient system. Thank you.
Thank you very much. I think the most significant thing, you've said quite a lot of significant things, Ms. White, but I think the most significant thing there is the importance of counsel thinking more about turnover than about the units. Some counsels specialize, and there's a debate out there as to whether it's their fault or it's the fault of the system for making it possible for them to delay. But some counsels specialize. We're all practitioners. We know each other. Some counsels specialize in dilatory tactics. And this is, you have certain jurisdictions that you say is a defendant's jurisdiction because you can tie things up. Some will tell you that, no, if you go to that gentleman, you can be rest assured they can't get out of court for the next 10 years. You will lock it up in preliminary objections and all sorts of gymnastics. We need to address the system. Is it the system or is it the operators? Our last speaker, Mr. Oshutoku, has the benefit of being, I call him an insider who looks in from the outside. He's Nigerian, very Nigerian, but then he doesn't practice here. He's always practiced in the UK. He's a partner with the UK firm of Bowen, Leighton, Paisner. And he's been involved in some of these things, so he's seen just how bad the system here can be. And I think he has taken advantage of it. He has also been the victim of it. So, Shogu, could you please tell us what you think are the most important things we need to do to address the inefficiencies in our system, having listened to all that has been said?
Sure. Thank you, Tunde. Good afternoon, ladies and gentlemen. Now, as Tunde says, I have a perspective, a sort of insider's view from outside. And I've had the privilege of working with many Nigerian law firms and Nigerian colleagues, Tunde included, my lord when he was in private practice as well. And I think what I have to say should not be taken as, because I know we Nigerians, we don't like people criticizing us. We can criticize ourselves, but we don't take too kindly to too much external criticism. So what I have to say they're meant in the spirit of collaboration and knowledge sharing. But just to set the scene, as Tunde mentioned, I've worked in cases involving Nigeria, and I have had experience of the judicial system as a practitioner. And I suppose the most opposite example I can give of the sort of issues I have witnessed arose out of a matter where my firm was acting in a case that arose out of the collapse of the banking sector, or the crisis of the banking sector in 2008. And we were instructed to pursue a claim against a particular individual. And the claim proceeded in England, but also proceeded in Nigeria. That claim got to judgment in England, dispensing of all appeals and rights of appeal to an enforceable judgment from 2010, possibly to the middle of 2013, so 3.5 years. The parallel claim in Nigeria, albeit on a civil claim in England versus a criminal case here, has not been resolved. Now, that case, and I need to speak very carefully, I'm not putting it all down to the inefficiency of the system, because I'm sure the individual in question has many robust defenses against the claims, but I dare say that many of the delays were born of some of the inefficiencies. So using that as a backdrop, and bearing in mind I've only got a short while to speak, what are the things I see, the sort of comparative analysis that I can bring to bear from practicing in England, where things work more or less efficiently? That's not to say it doesn't have its own problems, it certainly does. But what are they? And if I had a magic wand and I waved it, what could I fix? The first is a theme which has been spoken about quite a lot by the other panelists, which is that of scheduling. I just struggle to understand how a system can run without people knowing that when they turn up in court, they will be heard. It is an inefficient system. It wastes the time of the court. It wastes the time of the users of the service. And I'm not quite sure. I mean, we were having a discussion before we came in about whether that is actually a symptom of the system not working, or it's in fact a sort of cause. You could look at it as either. But in England, you do have a system where you will fix generally speaking, you will fix a time for your appointment. You may need to fix it with the other side's counsel so that everybody knows that when they turn up, they can be heard. You'll fix it with the court as well, so everybody has a dialogue and you all appear at a time convenient for everyone. The other issue, again, which has been raised is that of costs. I think that there needs to be a balance struck between the access to justice, the administration of justice, and an allocation of the burden of what it takes to run an effective, efficient justice system. Because it cannot, I don't think, fall entirely on the taxpayer to fund the system. And I'm enlightening two issues there. There's a question of who pays to go into the system and the who pays when you're in the system. I think that the issue fees need to be looked at, and I think that the question of awarding costs against the losing party will, to a certain extent, make people think long and hard about whether to bring on meritorious claims. The other lesson I think could be learned is the use of technology. Again, having witnessed it firsthand, and with due respect to my Lord, I simply cannot understand how in this day and age a judge has to write in freehand a note of the evidence, and that it's a judge's handwritten record, which is the record of the evidence. You walk into you walk into any courtroom, particularly a commercial matter in the commercial court in England, everybody, and this technology is not new. We're not talking rocket science here. It's instantaneous. Everybody is reading from there's a real-time transcript. Counsel is marking out the bits of the evidence that he wishes to cross-examine on. The judge is making notes as it goes along. Everybody knows what the record is because they're all reading it. And I think that to have a system where the judge painstakingly has to write out the evidence and has to wait for the witness to finish. I mean, no wonder trials go on for years. So I think those are easy wins. And I do recall, going back to Mr. Arthur Warre as Solicitor General and the Lagos State moves to modernize the courts, they sought to bring in, if I recall correctly, stenographers who could actually have a stenographic record of what was being spoken about. I dare say I don't know what has happened to that project, but I thought it was a laudable project and one which should be emulated. Now, just finally, this is a catch-all. I put it under the heading of a willingness to try new things. To me, it is usually a bad answer to a question, why are you doing things this way? To say, because we have always done it that way. To me, that is not an answer. That's an excuse. I'll give you an example. In the case I was just talking about, the criminal trial had proceeded to a point, criminal trial in Nigeria had proceeded to a point where evidence had been heard, the judge had closed the evidence, he was writing his judgment, and he was elevated to the Court of Appeal. Great for him. Congratulations all round. But he was elevated before he finished writing his judgment. Could his elevation be delayed until he finished his judgment? No. The case had to start afresh. Now, I'm sorry, but when I heard that, I said, can we not come to an arrangement where he finishes his judgment and then takes up his pace in the Court of Appeal? We were told, well, no, that's the way it's always been done. Once you are elevated, become functus officio. But that is to me, and I'm sorry if I'm being blunt about it, it's 2 years of court time wasted, simply for a procedure. In England, when you're elevated to the bench, you finish your portfolio of cases. You sit as a Court of Appeal judge while you're still dealing with your cases below. There's no reason why that can't be done. So I think that I've probably been a little bit too strident in my criticisms, but they are heartfelt and they come from a good place. And I hope those snippets, they are probably tips of the iceberg, and I haven't really gone into the substance as my fellow panelists have. But I think, after all, it is those who wear the shoes who know where it pinches, as they say, and therefore it is where those deficiencies make the most impact on the users of the court system that we can start to see changes being made. So thank you very much, ladies and gentlemen.
Thank you very much, Rex. That we need to try to do as a profession is to move these interventions and these events forward beyond talking, because we all know what the problems are, and we talk about them all the time. One thing that has come across quite clearly to me is that on this issue of the administration of justice and improving the efficiency, there is no clarity as to who is responsible for resolving this issue. In my experience, well, not experience, I'd say in the little research I did into this topic just when we were planning this session, I inquired into various other jurisdictions that have had similar problems. And the one jurisdiction that stood out was Malaysia. Malaysia, just like several years ago, they came to Nigeria and took away our palm kernel, and we now import palm oil from them. They also had a similar problem some years back, I'm told. They had serious backlogs in their judicial system, things didn't work, cases took forever. And it just took one man, I'm told, a Chief Justice, not the immediate past Chief Justice, who decided that this was enough. And he grabbed the system there, he grabbed the bull by the horns. He got the necessary buy-in from his colleagues. He got the necessary buy-in from the executive and turned the system around. Today now, Malaysia is competing, or is attempting to compete with Singapore in terms of the efficiency of its judicial system. So it's not rocket science. We can do it. But somebody needs to grab the bull by the horns and decide that, okay, enough is enough. And as I said, for me, the greatest worry is that if lawyers think that by developing the skill to tie matters up in court for 10 years, they're doing their clients a favor. They're not. They're doing us a disservice, because if we have an efficient judicial system, it will address a lot of the ills that plague our society. Ills as mundane, they might appear mundane, but you have people who are killed by hired assassins, and you don't know why. Now, some of these commercial disputes that result in people being killed by hired assassins is because people have lost faith in the system. Why would I take a dispute to court if he's going to get locked up for 10 years? I'll solve it my own way. I'll just kill the fellow. And then you can't attract business. You can't attract foreign direct investment, because foreign direct investment is a competitive industry. So an investor who says, if I come into your country and there's a dispute with my joint venture partner, how long will it take to resolve the dispute? And he's told that in Nigeria it will take 10 years, in Ghana it will take 2, in Ivory Coast it will take 3. The choice is very simple. Except you're selling something that he cannot do without, he will go somewhere else. So these are things that I think we need to take particularly seriously, and I'm hoping that the SBL and the larger body, the NBA, will decide that enough is enough in Nigeria as well, and that we need to deal with these problems decisively. We don't have much time. We started late, and there's another session after us, so we're already eating deeply into their time. But we will still take questions. We will take questions. We will limit the questions to 2 from each side of the hall. I don't see any hands on the left, so I will transfer. Okay. So, starting with Mrs. Justina Lewa. Who's got the microphones, please? Microphone. Please tell us your name, and if your question is directed at any particular person, please say who. And please keep the questions short. Thank you.
Okay. Talking about delays and frivolous matters, I like to relate it to one aspect of where I work. I work with Sterling Bank, and that is in the area of legal mortgages. Sometimes I wonder what the essence of a legal mortgage is, because the borrower would have taken money from the bank, he defaults, you write the letter of demand, he rushes to court, and the judge grants an injunction, and then we are there in court forever. Sometimes this injunction, they can stand on it and even use that alone to go to the Court of Appeal, and your bad loan keeps growing, CBN is disturbing, provide. So I'd like to ask, or I'd like to find out from my Lord who is here now, that can you not say to this plaintiff who rushed to the court, ask him whether he owes the bank or not. If he owes, go and pay at least the principal, and then come back and decide on the interest. I have more, but since you said I should keep it short, I'll just let it be.
Thank you. I think it's to Justice Dingba, yes. The gentleman at the back there.
Good afternoon. My name is Patrick Gongo. Please, my question is in respect of what we do as lawyers to delay.
Sorry, we're having challenges hearing you at this end, because it seems the speakers are facing the audience. So if you could please speak up a bit.
Okay, sir. I said my question borders on the role lawyers play in delaying justice. And I want to ask, is there any mechanism that NBA can put in place in terms of charging fees in terms of charging fees, because I discovered that most of all this delay comes from those lawyers that charges appearance fees. If there is a mechanism in place that all lawyers must charge upfront, when you charge upfront and you know that you need to deal with that matter as quick as possible, you will be diligent and you won't waste time. So if NBA can have a mechanism to regulate how we charge fees. Thank you.
Thank you. The gentleman in front.
I was just wondering, my lord, whether you do not perhaps oppose.
Sorry, your name, sir?
I'm Professor R.A.C.E. Achara. I'm from the Enugu branch of the bar. My lord, I'm just wondering whether perhaps some of the difficulties we face regarding delays do not come from a problem of perception in terms of the chilling effect that comes from a misunderstanding of decisions of the Supreme Court. You know, many times judges at the lower rungs, even though they know that one counsel or the other is delaying proceedings deliberately, they know they can stop the thing either by costs or by even disciplinary provisions against that lawyer that is delaying proceedings. But somehow, when you look at the rulings these judges do, giving leeway to these people to continue, you will find that they seem scared about what the appellate courts will do. And I'm wondering whether it's not based on a misperception of what the Supreme Court has been saying in some of these decisions. Again, there are some issues that seem worrisome. I don't know if it's not based on an attachment to old positions. For example, the trial within trial. You see, even in 1990, Nnewekago JSC had indicated, look, this whole thing is based on jury system. When you had lay jurors sitting there, you don't want to bias their minds by hearing some evidence that might later be expunged. So you say, okay, we're going to have a trial within trial. But now you're sitting before a trained judge. Why would you have trial within trial? There's several such problems, and I think that perhaps it's a problem of theory deficit. And I'm wondering whether my lord agrees with this.
Thank you very much. Thank you very much. Well, we haven't had any ladies, so we'll take a question from the lady in the fourth row.
Good afternoon. I'm Adeola Oladejo. I have had some applications at the High Court.
Sorry, we can't hear you. Please tell us your name.
Adeola Oladejo. I've had some applications at the High Court by way of motion ex parte, which have suffered several adjournments, going to 4 months now. I've checked under the rules to check the law guiding the hearings of motions ex parte. But I want to ask, is there any law that says that motions ex parte can be adjourned till 4 or 5 months without not speedy hearing?
The gentleman in the third row. This gentleman.
Thank you very much, Mr. Chairman. My name is Max Ikongbe. My question is directed to Mr. Bimbola and Mr. Oshuntokun on the issue of jurisdiction. Sometimes the way we lawyers handle jurisdiction, you would think it was the 11th commandment God gave to man. Can we not change this issue? I'm thinking to add to the suggestion made by Mr. Abimbola. Would it not be possible for jurisdiction, when you file a writ of summons or an originating summons, a column should be put there for you to state, I believe this court has jurisdiction for so and so reason, so that the defendant, when he files, that issue can be trashed immediately. And if the matter slips, at the level of the Court of Appeal, should judicial not be handled like judgments given after 3 months? There must be some material injustice. If my Lord Justice Dingba or a judge in Lagos High Court, trained in the same schools, they have the same qualifications. So what really makes a judgment given by a Lagos High Court that maybe touched on an administrative decision of the federal government, incompetent on its own? I think there should be something to show that there was material injustice. Say there was special provisions on admiralty law in the federal high court that the defendant would have benefited from if the matter went on in the federal high court. So I'm thinking we should rethink jurisdiction and then appellate powers. There must be a show, or there should be a showing of material injustice on issues of jurisdiction.
Thank you. And we'll take the lady in the, I think, about the 8th row. Yes. And that will be the last question.
My name is Bridget Osazoa. I'm thinking, is it possible for our rules to be amended to reflect the growing change in the society, to reflect this technological age? For example, the Court of Appeal rules was amended in 2016, and then you have, especially Court of Appeal Lagos, they have issues with space. And so you see a lot of paperwork everywhere. This is because the rules provide, if you're going to file appellant's brief, file 20 copies. And you have a panel of 3 people. So who will read the remaining 17 copies? And then they amended it in 2016. Instead of removing the number of copies, maybe reducing it, they said we should be filing now with 2 flash drives. So in addition to the 20 copies, you now have to buy 2 flash drives every time you have to file a matter at the Court of Appeal. So give or take, in the next 5 years, you will have a building filled with paperwork, and you have another building filled with flash drives. I think we should look at our rules. Thank you.
Obviously, that was a very interesting question, but unfortunately, at this end, we can't hear. We didn't hear, but yes, we'll take answers. I think Mrs. Lewer's question was addressed to Justice Dingba. I think quite a few of the questions were actually addressed to Justice Dingba. So.
Sorry, madam, your question was on the issue of the grant of injunctions and abusive use of that to truncate, commercial that you have. What I just want to say is that, there are principles which govern the granting of injunctions. Obviously, a key component of that is that these are things that you grant, of course, at the discretion of the court, and courts exercise that, very differently. I can only speak to you about the way that I exercise my own discretion. People who have come to my court, they will tell you that most times people come to me and they want, interlocutory orders, either injunction, all of that. I always tell them, you must understand that I don't do that sort of thing. Let us just get to the heart of the matter, okay? And I've realized that, once you cajole them and they agree, to defile the interlocutory, matters, to get onto the substance of the matter, most often, I always, try to finish the matter and write the judgment as quickly as I can. There are matters which I've disposed of within 2, 3, 4 months, once they agree to this, what I've spoken about now. So that's my own attitude to it. About commercial agreements, I know recently in my court, I did ask someone who came with a similar suit as that. I asked the lawyer, this agreement you're suing on now, upon which you're trying to get an injunction from this court, tell me, did your client comply with all the terms of this agreement? It's a financing agreement. He was saying, he was just dancing around. I said, okay, I want to ask you another question. This exhibit that's part of this originating summons, your key exhibit, upon which you're asking me to intervene, to grant my own orders. Did you read this agreement? He was very uncomfortable. He said, partially, that sort of thing. So from the manner he answered the questions, of course I knew what I was going to do, and that has been my own approach, okay? Obviously I didn't I'm not going to grant injunction, I can tell you, and that's my approach. Why? Maybe because I also come from a commercial background, okay, and I told him this agreement, look at this clause, that clause, that clause. He hadn't done that, so that's the thing I do. That then takes me also to the question which Professor Achara, the point you raised. For me, it's all about case management powers, really. This issue of delays and wrong perception of what the appellate courts have decided on some of those issues. I think it all boils down to the case management powers of the judge, this issue of delay. You see, the terrain is a very difficult one, and it is made largely so by some of the lawyers who are here and the litigants as well. Most times the judge wants to exercise his case management powers to get on with the hearing of the matter. Like the example I gave you about telling them, I'm not going to do the injunction, let's get on with the thing. What are you going to get? Next minute, 1 day, 2 days, someone sends you a link from Sahara Reporters to see where someone has written nonsense about you, abusing you, saying, why is the judge doing that? The people didn't want to hear it. Why is the judge interested in trying to, get on with the matter? They apply for adjournment, you're refusing that, all of that. So that makes even the environment of the work for the judge very difficult to exercise their case management powers. But my own philosophy about it is that as long as my heart is clean, and as long as my conscience is clean, I have to do the job the way I see it. That is my guarantee, because I don't know what the NJC will do, what they do, but as long as my conscience is clear, as long as I'm acting from the appearance of motives, I can exercise the powers which the court has given me. And what I want to say is that even when we have like a forum for judges, we have to speak sometimes as carefully as we can. I also try to even tell my colleagues, it's all about exercising your case management powers. That has to be exercised. It's been given to you by the rules. This issue of are you going to grant adjournment is at your discretion. Why would you grant it, if it's not merited? Because if they're going to write petition against you, and so what? Is it going to kill you? But the problem is that sometimes some of those wrong petitions, they've killed judges, their careers. So that's the difficulty. All of us have a role to play to also control running our clients, to prevent them from creating an atmosphere of fear and intimidation against judges, to prevent them from exercising their case management powers. On the motion ex parte, I don't know. You said something about why would the motion ex parte be adjourned for 5 months. I don't know whether that's what I heard. It would be very difficult for me to comment on that because I don't understand the peculiar facts, circumstances. It's possible that the circumstances of that particular, incident, warranted the motion ex parte being adjourned for 5 months. Okay, that's all I can say to that. Amendment of the rules, yes. Currently, the Federal High Court is undergoing a process of amendment of the rules. And I think a circular was sent to the NBA for people to send in their contributions towards that amendment. So there is scope for the rules to be amended to accommodate the things which are happening now, technology and all of that. Even if you look at the current rules, there are also provisions that accommodate this as well. Okay, thanks.
Ladies and gentlemen, unfortunately, we have run out of time. As I said, we were having challenges anyway, hearing some of the questions, but I'm told that we're eating too deep into the time allocated for the next session. The discussants, the speaker, they're still around, so if you feel particularly strongly about this issue, like I do, please feel free to take them up on this after the session has ended. Could I now please ask you to join me putting your hands together for the speaker and the discussants. Thank you very much.